waiting for Chairman Johnson. He is on his way, and given that we lose the room shortly, he's cleared us to go ahead. I'm delighted to recognize my original co-sponsor here, Senator Blumenthal, and also Congressman Cicilline of Rhode Island and Congressman Jones, who have legislative measures that are incorporated into this bill. Let me start by saying that you can't understand what is happening at the Supreme Court unless you understand the concept of agency capture. And I will leave that to all of you to figure out, because there is an abundant literature in the field of economics and there is an abundant literature in the field of administrative law on agency capture. The Center for Media and Democracy has reported that the spending on the effort to capture the Supreme Court has hit $580 million. So this is no small effort. While it is not small, it is very secret. We can't trace that money back to who is behind it because it gets filtered through front groups that have managed the process of Supreme Court capture. And when you have a court that is in that predicament, transparency becomes all the more important, as recent news shows. And this bill will address some of those concerns, particularly, for instance, regarding recusals. A Supreme Court justice is now not required to address why he or she doesn't think he or she needs to recuse. And if a party thinks that they really ought to have recused, they have no recourse. Everybody knows the problem of being judge in one's own cause. The justices are judges in their own cause as to recusal. There's no penalty for getting a recusal wrong, and the level of analysis is very weak. In the case of Americans for Prosperity Foundation versus Bonta, which was a very important dark money decision, the court seems to have paid no attention to the fact that Americans for Prosperity and the Americans for Prosperity Foundation are effectively identical organizations. That is a corporate veil you could pierce with a banana. And this law would require them to look through those corporate veils. We also see flotillas of amicus briefs appear, again, from organizations that don't really exist, whose purpose is only to hide who the real interest is behind them. And they appear in flotillas of a dozen at a time, coordinated and orchestrated. And in the case of AFPF, because it was so important to the dark money operation, 50 of these organizations turned up at the certiorari stage. Another point has to do with personal hospitality. The court is now allowing its members to accept personal hospitality. I put the word personal in quotes because it's allowed to accept personal hospitality from people the justice has never met at commercial resorts and facilities. How could that possibly make any sense? So we are really pleased to be working together in bicameral fashion to, at long last, get a code of ethics and some enforcement around the Supreme Court. It could not be more timely now that we have a captured Supreme Court that needs that extra layer of accountability. And with that, I will turn to my friend and colleague in this effort, Chairman Johnson.